Hello, YouTube land. It is me, Lauren Cadillac, Cadillac Law. As always, I'm here to teach you about stuff I know, but I'm not creating an attorney-client relationship, and nothing you hear here is like legal advice. I'm just trying to get knowledge out there and share it with folks. So today, we are going to talk about trespass to try title and quiet title lawsuits. I know it's thrilling, right? Okay, so here's what happens. This happened a lot more in the past too, especially like in the 80s and the 70s when people like really trusted each other, okay? Let's say I go to my neighbor and I'm like, I need to buy a house. And he's like, I need to sell a house, but I can't get a bank loan and he just needs the mortgage paid. So we create this arrangement. I'm going to pay the mortgage, blah, 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 yada, yada, yada. Okay. So we go through that and we do that. And I pay the mortgage for 10, 15, 20 years, whatever. I pay it off. He never records a deed. Then he dies. So the house is in his name, but I've worked out our arrangement. I've paid it off and now he's deceased. What's a girl to do? The actual technical process to resolve that issue here in Texas is going to be suit to quiet title. There are two types. It's trespass to try title and then quiet title. And trespass to try title is for when the other party is in possession, and quiet is when you have possession. So when my client is living in the property or they're running their business out of the property, whatever it may be, we are going to do a quiet title. Now, we actually put both in our pleadings because sometimes we're wrong, sometimes the law is interpreted differently in one court than another, so on and so forth. So I put both because you never know. You never know. And typically when the situation is that, you've paid it off and the person passed away and, you didn't know their relatives, whatever it may be, typically that process is relatively easy. We go file this pleading. We ask the judge if we can do publication. We do notice by publication, which means that we put in a newspaper that this lawsuit is pending. That goes on for a few weeks. Once that's done, then the judge appoints what we call an ad litem, which I totally have a video about wherever, and you can watch so you can learn what an ad litem is. The ad litem then tries to find the people we published, and in this case, in the case when someone's dead at least or deceased, the ad litem is looking for like their heirs, right? Because they're gone, or their estate. They're trying to find the people who are in charge. They report. So I've had one case where an ad litem actually found people. Once they found the people, I served those people. Those people never responded. Dead people don't respond. And the typical, most of these people like have no idea about this property. Also, usually, my clients have gone through years of paying for it, so it's not like they would even have much of a claim. So most people just ignore it, and then we do a default. We take the order from the judge, we record it in the county recorder's office on that piece of property, and boom, you're the rightful owner. It's really easy, actually, or it should be. Nothing is easy in the law, but it should be easy, and it is kind of a little bit of an easier process than other types of lawsuits, like when you find the people, or back up, when you enter into one of these agreements, the person's still alive, but they're refusing to sign the deed. I get that a lot, and I get people who have accidentally or maybe purposefully entered in an executory agreement, and I have a video about contract for deeds, which is executory agreement, so you should totally watch that. If you're a person selling and you've used an executory agreement, you need to call a lawyer ASAP and get out of that and figure out how you're going to fix that problem. You're a person who's buying and you've entered an executory agreement, and there's some kind of dispute, you lucked out. The law is really, really written for you. So in the cases though where there's a title dispute, or let's say you've purchased it through a contract, you paid it off, and this deed still has not been signed over. Maybe no one's actually fighting about it, right? But the deed was never signed over. That is when we are going to do the quiet title and the trespass to try title. If there are people to respond, that lawsuit will take longer. It will be a real lawsuit. There will be discovery, blah, 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 blah. And usually we end up going to mediation, coming to an agreement, have the judge sign off on it, record it in the county recorders. It's yours. So these are complex lawsuits. I mean, these are very complex topics. And like I've just referenced 3 or 4 videos here to help you kind of understand this more. If you think you're in a situation, or you know you're in a situation where you are the owner and there's no deed, or you sold a property and you haven't deeded it to someone yet, just give us a call, call a lawyer, let's talk about it, let's see what we can do for you, let's figure out how to minimize your risk and maximize your profits, okay? No need to freak out. Hit like or subscribe though, because that will make the algorithm gods happy. All right. If you need us, 972-845-1200. Thanks for joining me today.